Hi, I'm Melanie with the League of Women Voters of Kansas City.
Because of the sensitive nature of this issue, we want to start with a statement made by Justice Blackmun as he delivered the 7-2 majority opinion for the Supreme Court in the Roe v. Wade decision in 1973. We forthwith acknowledge our awareness of the sensitive and emotional nature of the abortion controversy, of the vigorous opposing views, even among physicians, and of the deep and seemingly absolute convictions that the subject inspires. One's philosophy, one's experiences, one's exposure to the raw edges of human existence, one's religious training, one's attitudes towards life and family and their values, and the moral standards one establishes and seeks to observe are all likely to influence and to color one's thinking and conclusions about abortion. At the time Roe was decided in 1973, nearly all states banned abortion, except in limited certain circumstances. Between 1967 and 1973, 4 states repealed their abortion bans entirely, while 13 others enacted reforms that expanded exceptions. For example, to save the patient's life, if the pregnancy was considered dangerous for the physical or mental health of a patient, or if the pregnancy resulted from rape or incest. Roe v. Wade held that under the 14th Amendment and the Due Process Clause, women had a constitutional right to privacy to choose to decide to have an abortion in the first trimester. A state could restrict but not ban abortions in the second trimester. In the third trimester, when a fetus is viable to survive outside of the womb, a state could ban abortion except when necessary for a woman's health or to save her life. The next major case was Planned Parenthood v. Casey decision in 1992. In Casey, the Supreme Court reaffirmed a woman's right to an abortion granted in Roe v. Wade. But Casey also gave states more leeway in passing laws restricting abortion by establishing that restrictions on abortion were unconstitutional if they placed an undue burden on a person seeking an abortion before the fetus is viable. Examples of restrictions that were not considered burdensome: requirements on healthcare centers, mandatory waiting periods after initial consultation, require that women get ultrasounds, and require that women get counseling. That brings us to Dobbs v. Jackson, Women's Health Organization, decided in 2022. The Dobbs case was a legal challenge to Mississippi's 2018 Gestational Age Act, which had banned abortions after 15 weeks, with exceptions only for medical emergencies or fetal abnormalities. In Dobbs, the Supreme Court ruled 6-3 to uphold Mississippi's Gestational Age Act and 5-4 to overrule Roe and Casey. As a result, abortion is no longer protected by any constitutional provision. The current law on abortion in Missouri comes from Missouri Revised Statute 188.017. This so-called trigger law was passed by the Missouri legislature in 2019 and became effective in June of 2022 when the U.S. Supreme Court overruled Roe v. Wade and Casey. The law bans abortion except in medical emergencies and indicates that healthcare providers who violate the law can be guilty of a Class B felony, which can result in 5 to 15 years in prison, and have their medical license suspended or revoked. That brings us to Amendment 3, that seeks to establish a right to make decisions about reproductive health care, including abortion and contraceptives, without governmental interference. The fair ballot language. A yes vote establishes a constitutional right to make decisions about reproductive health care, including abortion and contraceptives, with any governmental interference of that right presumed invalid. Removes Missouri's ban on abortion, allows regulation of reproductive health care to improve or maintain the health of the patient, requires the government not to discriminate in government programs, funding, and other activities against persons providing or obtaining reproductive health care, and allows abortions to be restricted or banned after fetal viability, except to protect the life or health of the woman. A no vote will continue the statutory prohibition of abortion in Missouri. If passed, this measure may reduce local taxes, while the impact to state taxes is unknown. And the fiscal note. State governmental entities estimate no cost or savings, but unknown impact. Local governmental entities estimate costs of at least $51,000 annually in reduced tax revenues. And opponents estimate a potentially significant loss to state revenue. The ballot title incorporated the fair ballot language, which you have already seen, so we will not read through it again. Amendment 3 includes language that would allow abortion to be restricted or banned after fetal viability, except to protect the life or health of the woman. Section 8.1 of the proposed amendment goes on to define fetal viability as the point in pregnancy when, in the good faith judgment of a treating healthcare professional and based on the particular facts of the case, there is a significant likelihood of the fetus's sustained survival outside the uterus without the application of extraordinary medical measures. To help us understand and navigate the term fetal viability as used in the initiative petition, we are quoting from an article by the American College of Obstetricians and Gynecologists titled, "Facts Are Important: Understanding and Navigating Viability." Viability is often used in medical practice in two distinct circumstances. First, viability addresses whether a pregnancy is expected to continue developing normally. In early pregnancy, a normally developing pregnancy would be deemed viable. Secondly, whether a fetus might survive outside of the uterus. Later in pregnancy, a clinician may use the term viable to indicate the chance for survival that a fetus has if delivered before it can fully develop in the uterus. Fetal viability depends on many complex factors, of which gestational age is only one. Many other factors also influence viability, such as sex, genetics, weight, circumstances around delivery, and availability of a neonatal intensivist healthcare professional. While it is impossible to definitely declare viability, there are several situations in which a pregnancy will never be viable, regardless of gestational age. Tubal ectopic pregnancies will never be viable, and the treatment for ectopic pregnancy requires ending the non-viable pregnancy. Those who support Amendment 3 say, passing the amendment will end our state's total abortion ban and make sure Missourians and their families can make decisions that are right for them. Abortion is an element of women's health care. The decision about whether to have an abortion is a personal choice that should be made by the pregnant woman, their families, and their healthcare providers. Missourians should have the power to make decisions about their own reproductive health care, including abortion, birth control, and miscarriage care, without interference from politicians. Legislative bans on abortion can overlook unique patient needs, medical evidence, individual facts in a given case, and the uncertainty of outcomes in favor of defining viability solely on gestational ages. Those who oppose Amendment 3 say Missouri's current law banning abortion should remain. Human life begins at conception. The pregnant woman's rights should not outweigh the fetus's rights. The time to decide whether or not to have a child is before conception, not after. And it gives powers to judges and the government to force Missouri taxpayers to fund abortions.
Thank you for taking the time to become an informed voter.